Welcome, everybody. It's a pleasure to see you here at this panel, which will be about the EHDS. For the 1% of you who haven't heard of the EHDS, that's the European Health Data Space, and the challenges and opportunities that it brings. We know this is a very topical subject. We know it's very popular. We recently had the honor of hosting a symposium here in Brussels on this subject, and it was well attended with a diverse array of speakers and opinions. So we're delighted to host a panel on the subject here. And we know that this is a subject that brings passionate opinions on different sides, and we hope to see some of those today. So please don't be shy. Feel free to ask a question. Yes, why is the EHDS here? Well, we all know the value of secondary health data sharing. Many of you work in industry sectors or types of research that make use of secondary data. Its value is becoming increasingly evident. Several things are increasing this value. A number of them, the increased connectivity, think of the fact that everybody can share data a lot more easily. The increased digitization of all areas of healthcare and research. Think of the electronic health record, the most obvious, but not the only one. And then increasing forms of computing power, including forms of AI, make the value of this secondary data more obvious, increase the amount of things we can do with it. So we know that secondary health data is becoming more obvious, it's becoming more desired, and it will become further desired in the future. So this is why this arouses such passions, because there are costs to not having it available, and there are concerns to having it increasingly available. These we will talk about today. So we all know that the GDPR in theory allows the sharing of secondary health data. There are a number of potential legal bases that can facilitate this. The GDPR cannot be said to be hostile to research. I think we can all probably agree with this. The problem is that the way the GDPR is implemented, many people would argue, has not resulted in an optimal sharing of health data, including secondary health data. That is one of the challenges the EHDS is meant to address. And as we know, if you may have seen it at another panel, or you may have seen it at other events, you may have read the early literature on it, or the discussion, it arouses serious passions. A lot of people have strong gut feelings for or against. Some are very concerned about privacy harms, about the power of big commercial organizations. Others are motivated by the benefits that can be garnered by the increased sharing of health data, especially for research purposes. So our panel is not, I would say, mostly about these strong gut feelings. It's going to get into a bit more nuance, hopefully, and explore some different perspectives about the challenges and the opportunities of the EHDS. So we tried to put together a panel that has an academic perspective, a regulatory perspective, a healthcare perspective, and an industry perspective from the pharmaceutical industry. So from the academic perspective, we have Anastasiya Kiseleva, and she is a colleague of mine at the VUB in our group, the Health and Aging Research Lab. She is based both at the VUB and at the Faculty of Computer Science, ETIS, in Paris. And she's going to present a positive vision of the need to share health data and what the EHDS can bring to that. Then we will have Nerea Peris Brines. Apologies if I... Brines. Okay, excuse me, I'm sorry for that. I should have checked with you before. And she is a legal officer at the European Data Protection Board and the European Data Protection Supervisor. And she is going to look at, I guess it's fair to say, concerns that exist around data subject rights and implementation under the EHDS. Following that, we will have Sara Roda, who is also my colleague at VUB. But she has two hats. She also works for a large European association of doctors, CPME, French acronym, which I can't remember. I'm sorry. Okay, thank you very much. And she is going to present, I think it's fair to say, mostly concerns from that doctors have put forward, some of them motivated by their traditional need to respect patient confidentiality, some by more practical reasons. And finally, we have Pauline Granger. Pauline is part of the legal team at Sanofi. She is not my colleague, but I work with her on an EU IMI project that concerns the reuse of clinical trial data. Pauline has a lot of practical, on-the-ground legal expertise about the challenges that reusing this data brings. And she will talk about industry concerns about what the EHDS will mean, particularly, I think, from the perspective of clinical trials. Okay, so the format will be, I will give 10 minutes to each speaker. Please try to more or less respect that. Then I will ask, depending on the time, a few short questions after each speaker. And the aim is to save up a bit of time, so at the end we can have 15, hopefully 20 minutes of participation from the audience. If things run over, I will cut short my questions so that we can leave more time for your participation. Thank you very much. So the first speaker, Anastasiya.
I'm going to sit if you don't mind. So, hello everyone. It's great to see many familiar faces and places as well, and also the new ones. So my name is Anastasiya Kiseleva, and I'm going to take quite unpopular position nowadays. I'm going to highlight the positive sides of the EHDS proposal. One might call it the devil's advocate, but I'm going that one is not in that room. At least after my presentation, I hope you get this vision. So, wait a second. Yeah. So nowadays we discuss a lot about data. It seems like a new topic, but actually in the healthcare it's not. Healthcare has been always empirically informed, and health data are the blood running through the veins of it. So we can see it in clinical trials, gathering data and collecting data for that, and also in when the doctor asks the patient, like, what brought you here today and how do you feel? It's also collecting data. But nowadays we have two great powers, vast amounts of data and also AI. So wasting these two great powers would be a shame, and it would mean also missing the opportunities to improve healthcare and our health, lives, and well-being. So, and the European Commission and the Europe in general sees data as a key enabler for digital transformation of healthcare. Looks great, right? Great idea, but what we have in reality? Wait, sorry. Where should I? Yeah. So reality is way worse than ideas. Recently, I came across the news on Twitter that Google promised to delete sensitive data about misuses of data. So what we can see from the news is that first, data is being used already. Second, it's being used by IT giants, and also it's misused. Of course, it happens in the US. In Europe, we have a bit better and stricter laws for data use. Can you change? Thanks. I didn't find anything happening like that in Europe. Maybe I'm biased because I was not attentive enough, but health data usage is happening with or without us. And also, according to the impact assessment by the European Commission, health data reuse is estimated at present to be worth around 25–30 billion annually. So what do we want? If it's already happening, why don't we take care of that? Why don't we what do we want? The risk of misuse or creating legal, technical, and organizational measures to do it right? I vote for the last option. Could you please change? Because we need rules for data usage. We need the use and reuse of both personal and non-personal data, which none of the frameworks currently deals with this issue. And also we have already quite a good piece of legislation to protect data. But we don't have anything that enables to make data usage. And they are quite different in the purposes they are following. So protecting is to preventing others from doing something with the data or limiting it, while usage is entitling others to use the data, to do something with data. These are quite different, and also we need to do it in one same framework. So we need to make the data use... no. Yeah. It's not working. No, it's not working. Can you press? So we need to make data use possible, but then we cannot just open the flow of data and to give it everyone. We also need to make it controllable. So we need to define who can do what with data. So define the rights and obligations of data, of stakeholders. And also at the same time, the whole idea behind the secondary use of data is to do it for the common good. So we should make it in the responsible way. And we can also say that the more we receive data, the more we should give as well. So we should also follow these three ideas. Thanks. So I think that EHDS fulfills these ideas, and I'm going to show how. So first, the EHDS makes data use and reuse possible. First, it creates rules for making data available by and for different stakeholders. It also improves equity to data. As we discussed already, the Google misuses. Nowadays, a lot of data in the hands of IT giants, and so opening access to different stakeholders will also make data use more equitable and more fair. Then we will have common technical and organizational standards that will enable to raise interoperability. Then also the EHDS is lending to very difficult legal landscape. I analyzed this issue also in the article that I wrote together with Paul de Hert. And there are two types of legal issues. First type is differences in the member states' regulations, because they have the competence to define their laws in health area and also to define their health policies. And so somehow to create something that is common for the member states, we had already a quite hot discussion this morning in another workshop on that topic. So we need to it's quite difficult to create something common for the member states that have so many differences. And then there is another type of challenges, is that the EHDS proposal is very linked to other legal frameworks. One is AI Act, the proposal, and then there is another set of rules for the usage of data, such as DG Act and the proposal for the AI Act. And it should be also compatible with these two frameworks, but they're also in the development process. So it's quite complicated also to do it all together. And then also, as I said already, there are two different regimes, there are two different types of data. One is personal data that should be protected by it's the purpose of its usage. But then there is also non-personal data, and somehow we also need to use two of them, and none of the current frameworks provides the legal solution for that. The DG Act and Data Act proposal are quite fragmented in that regard. They actually don't say how to use data. They quite limit the use of it. And then we have also, because of the architecture of the proposal, it also allows to use the data of deceased individuals. That topic I also addressed in another paper with Professor Beria, because it's not protected by the GDPR, and it might be considered as non-personal, but there are also differences in member states' regulations. So the EHS proposal gives the chance for that. The other thing that the EHS proposal gives is making data use controllable. So it will provide the whole environment through health data access bodies to use data. Then it also establishes the permitted and prohibited data use. There will be data permits, and the whole use will be limited by that. It will be data minimization and anonymization. Re-identification will be prohibited, and there will be also closed, secure environments. And finally, as I already mentioned, we should also think not only about rights or entitlements on data, but also our obligations when we receive data. Not only to give data, but when we receive data. And so the EHS proposal also establishes a lot of rules on data quality and data utility, which is also quite important in terms of AI. So as data scientists say, garbage in, garbage out. So, and it's going to be one of the main sources for AI testing and training. So it's very important also to ensure the quality of data. And then, again, like in the proposal, it says that the secondary use should contribute to the general interest of the society. So it's not that we just give data to everyone and do whatever you want with the data. We should also always see this purpose behind. So I think that actually, So I think that EHS proposal suggests the unique legal regime that allows the common use of two completely different types of data for stakeholders with different interests and purposes, among member states with different policies and laws, but in the controllable environment and in the responsible way. Of course, it's not perfect, and I'm sure that my co-panelists will cover that point. But I also want to show you that before criticizing something, we should also see the good sides of what we criticize. So I hope I managed this task with some technical issues, but still, if you want to read more on what I discussed, there are papers that I mentioned. And thank you very much for your attention. I will be looking forward to the questions. Thank you.
Okay, thank you, Anastasiya. Just one question. It's rather broad, so you won't be able to answer it in detail. Do you think it's realistic what is being asked of the health data access bodies? Because they have to make so many forms of analyses. They have to look at GDPR compliance and the many issues inside GDPR compliance, which not only require knowledge of the law, but perhaps a kind of expert knowledge of whatever form of research we're talking about in that specific context. For example, to determine what is minimization in a specific context. They also have to look at ethics. And then, as you were saying, they have, in terms of the potential grounds for granting a data license, they have these very broad notions about what is in the interests of society. I mean, do you think they will be able to, have people, or enough people to perform this exercise?
That's a good question. First of all, I should say that they have to find the solutions, because like there is no alternative. It should be controlled by the public bodies. And then also, I think there is also the impact assessment by the European Commission on how much is going to cost to build the infrastructure. I'm not sure if there is something about like how much specifically these bodies are going to cost, but like it's estimated. And I think also important issue is that these bodies should have people with different backgrounds. Because indeed, we will have so many areas to cover, technical, legal, organizational. So it should be like collective work to do something common. It's the whole idea of the HDS. Like, it's bringing together different expertise and different backgrounds and many differences. So the same way should be the health data access bodies, I think.
Yeah, from my perspective, I was wondering, will all in the various member states, do you think they will all be able to do this, including the small member states? And do you think there will be maybe a risk of forum shopping?
There is a risk indeed, but in terms of like costs, like so the smaller member states are going to have smaller amount of tasks, so it's going to be, I think, proportional. The issue of the shopping indeed, it's quite interesting, but I'm afraid we don't have much time. Maybe later, like after the.
Indeed. Okay, I pass to our next speaker, Nerea. Thank you very much.
Okay, many thanks. So I am Nerea, as Paul said. I work as I am a legal officer at the EDPB. This is the umbrella body comprising the data protection authorities of the member states and also the data protection authority of the EU institutions, the EDPS. The task of the EDPB is basically to ensure the consistent application of the GDPR, and in this context, the EDPB and the EDPS provided a joint opinion on the EHDS proposal last summer in July. I will, of course, focus on the aspects of data protection and how this proposal impact the right to data protection. In the joint opinion, the EDPB and the EDPS recognize that secondary use of data might be... Sorry, my slide is not there. That secondary use of data might bring benefits for the public good, considering the objectives of the proposal as well, foster research, enable innovation, even leading to better healthcare. However, there are still a lot of concerns from the data protection perspective and the risk that this proposal, in fact, weakens the protection of individuals in the right to data protection and also privacy. As you probably know, the proposal creates a legal obligation for data holders to make available specific categories of e-health data for secondary purposes. So this provides already a legal basis under the GDPR, right? Under Article 6.1c, you will have a legal basis for this processing. And it also entails an exception to the general rule of not processing sensitive categories of data, health data in this regard. However, there are a lot of concerns, as I said. One is, for example, what is the role of consent here? What role it plays. I think Sara will address this in her presentation. I will focus mainly on three types of concerns. First of all, concerning the purposes of the processing. The proposal provides a list of purposes for which data can be used for secondary uses. However, according to the EDPB and the EDPS, this list is too broad. There is a lack of delineation here, especially regarding these two purposes, the development of new products and also the training and testing of algorithms, all that contribute to public health or social security. This is very broad. It's a broad purpose, and there is a risk here that it's too broad and there is no connection, in fact, with the public health or social security. That's why the EDPB and the EDPS recommend that the proposal should clearly make a link between the purpose and the public health or social security. There is another concern that I wanted to discuss today, is the interplay with Article 9 GDPR. This is the article under GDPR that first prohibits the processing of special categories of data, and second provides exceptions to this prohibition. So under certain circumstances, sensitive data, which includes health data, can be processed. This article is only mentioned once in the EHDS proposal, and it's in a recital. Why is it a problem? Well, for example, health data access bodies are not explicitly required to assess compliance with Article 9 of the GDPR when assessing data applications to issue a data permit. They only are obliged, according to the proposal, to check that the provisions and conditions under the proposal are fulfilled, but no mention to Article 9 of the GDPR. It's in this respect, it's particularly relevant to take into account the obligation to provide appropriate safeguards when data is processed for research, which is under Article 92J GDPR and also Article 89 GDPR. This obligation to provide appropriate safeguards is very important and is not referred to in the proposal. So this is an aspect that needs to be clarified in order to understand how and in which cases these articles can be relied upon. The last one, okay. The last concern I wanted to mention regarding the purposes of the processing is actually the interplay with national laws, because Article 9.4 of the GDPR gives powers to member states to specify additional conditions for the processing of biometric, genetic and health data. And these conditions may be different in each member state. However, the proposal doesn't clarify how it will reconcile the conditions and the proposal with the different conditions in member states, and also how these different conditions between member states will be reconciled. I think Pauline will talk about this as well, but this is also something that the EDPB and the EDPS consider very important and needs to be clarified before this proposal is adopted, basically. So all in all, regarding the purposes, there needs to be a full compatibility with Article 9 of the GDPR in terms of purposes, but also safeguards and exemptions. Okay. So our next category of concerns are related to the health data access bodies. Here, and this is actually, the first concern is kind of linked to the question that Paul just gave to Anastasiya, is the expertise of the health data access bodies. So the proposal doesn't require the health data access bodies to have legal expertise, even though these bodies are going to be assessing the legal grounds, for example, proposed by the data applicants. How will this then happen when you don't have any obligation to have legal experts on this topic? So this is something that needs to be clarified in the final draft. Another concern is regarding the applicable law for cross-border data permits, linked to the forum shopping question, actually. The proposal aims to facilitate cross-border secondary use by establishing the national contact points and also a cross-border infrastructure. However, in reality, when there is the data users will still have to apply to one of the concerned data access bodies in order to receive the data permit. Probably these concerned bodies will be different depending on the case. And there is no clarification in the proposal as to the specific law that will be applied in this case. Will it be the law of the data applicant? Will it be the law of the health data access body? This has an impact on the legal basis that the data user has to identify and the data body has to assess, but also on the ethical aspects, for example, that are based on national law. So there may be a gap of expertise here that is not addressed in the proposal at all, and we think it's very important. The last two concerns regarding the health data access bodies are, first of all, the access to e-health data by public bodies. In the proposal, the public bodies are exempted to receive a permit from health data access bodies to access data for secondary uses. we believe that this shouldn't be the case, that the public bodies should always be subject to the requirement to obtain a data permit for two main reasons. First of all, because this is a way to ensure compliance with the requirements. And second of all, for transparency reasons. Public bodies have to, there is a high threshold on transparency on public bodies, and it's a very important element that they will be subject to this obligation to have data permits. Linked to this topic on transparency, there is an exemption on health data access bodies regarding the transparency obligations under GDPR. They are not obliged to provide specific information to data subjects regarding the use of their data. The obligation is only to provide general information on all data permits issued. In our view, this is a concern, especially considering the broad purposes and the categories of data that will be subject to secondary use, and we think that this actually undermines the objective of the proposal, which is to strengthen control over e-health data from on the side of data subjects. So if this is kept, this exemption, the proposal has to be amended in order to avoid abuse by the health data access bodies and include the obligation to carry out adequate and relevant assessments and justify when this exemption is used. And of course, any exemption to the rights of data subjects, which is this case, has to fulfill the conditions of Article 23 GDPR. Again, this is not mentioned in the proposal either. Very briefly, the last categories of concerns regarding the wellness apps and the data collected via these apps. So the data gathered via wellness apps or all these health applications falls within the scope of the chapter on secondary use of data can fall from two main reasons. It can fall directly within the scope insofar as data holders are processing this data, or indirectly once the user uploads this data in the EHR system. We think, and this is in the opinion, that this data shouldn't be subject to secondary use. There are questions on the reliability of this data, on the data quality, and here we have to make a distinction between data gathered or processed via medical devices. This is more reliable data since these medical devices are subject to specific standards and legislation. However, data gathered or created via these wellness apps, they are not as reliable. There's no rules to how this data is created. Also, this data is highly invasive. It provides information on every aspect of a person's life, and this can lead to very easy inferences about this person's life, whether accurate or not. And this, at the same time, can lead to specific risks of unequal and unfair treatment based on accurate or inaccurate assumptions. So we believe that this data shouldn't be used for secondary use, but if it is used, it has to be on the basis of the prior consent from the data subject after the data subject has been properly informed of this. And of course, there should be mechanisms to ensure that the choice of the data subject as to whether he or she wants to provide this data for secondary use and which type of data, this should be enforced, and there should be mechanisms to ensure that this choice is respected. I hope I stay within my time, and basically, yes, these were the main concerns, but yeah, my colleagues will elaborate. Thank you.
Thank you very much. One quick question. I'm sometimes a bit puzzled by the remarks on the possible grounds for granting a data access permit. You think they're too wide? But for me, the health access bodies will still have to ensure that the GDP will be complied with anyway. So I'm curious as to why this is such a major concern. And that's my only question. Afterwards, I would invite Sara to speak. Thank you.
Okay. Well, the issue is that there is no explicit reference. You could think, okay, GDPR applies in any case, so it has to be ensured. However, there is no explicit reference to this, even though it's such an important aspect, because at the end, what this proposal is doing is establishing an exception to the general rule of not processing this type of data, right? And also, you don't have an obligation to have legal experts assessing this. So we believe that this might lead to, in practice, this might lead to problematic situations in which the requirements under GDPR are not taken into account or are not properly taken into account because of a gap of legal expertise. And that's why for us it was an important remark. I don't know if I'm replying to your question, but if not, just let me know.
Perfect, thank you. Sara?
Thank you so much. Let's see if the slides are working. Yes. Oh, too much. Thank you so much, and I thank you for being here today and taking the time to listen to our panel. I just want to give a few words about CPME. CPME, it's a not-for-profit association. We represent national medical associations across Europe, and we cover more than 1.7 million European countries. So I had today the role of focusing on the secondary use, which, and I needed, and Paul asked me just to focus on 2 points. This was really a titanic effort to reduce the topics just to 2. But in the end, in the beginning, and just to support a little bit what Anastasiya said, we welcomed the proposal. We think there are many positive benefits that we were being discussed in terms of availability of electronic health records, the fact that there will be more interoperability and standards in this area. Also, new rights are coming for individuals, so there are indeed many positive aspects, but today was really, I just wanted to highlight the critical negative aspects that we still need to safeguard in this proposal in order to work. And so I will focus on medical confidentiality and professional secrecy, how to render compatible the patient rights, and our proposals for improvement. So indeed, the challenge begins with the definition of a data holder in the proposal. It's very broad, and health professionals fit into this definition. So they will have to make the data available for secondary use. The list of data that it has to be made available is enormous, so it includes electronic health records, genetic data, education, behavior data, lifestyle related to health, wellness apps, and other digital health applications. There is only a derogation, which in our view, it does not safeguard medical confidentiality and professional secrecy. The safeguard is that only micro enterprises will be excused to do this activity, so meaning companies under 10 employees. And if we go a little bit just for the principles to situate ourselves where we are in terms of the right to confidentiality, so this is an element of the right to respect for private life, because only by protecting that personal data you can enjoy the private life. And also we have to guarantee, because it's a special category of health data, a high level of protection. And again, we use Article 8 of the EU Charter. And still, the GDPR also safeguards the professional secrecy, so we still have the need to respect professional secrecy in Article 9. But I wanted to give you, what is it, medical confidentiality? So we talk, but what does it mean in practice? And so the definition is different in member states, and it also has evolved in time. Because of this, I prefer to talk about the definition and characteristics used by the World Medical Association, because it's widely recognized and accepted. And so I will just read out loud the highlighted parts, because it will be easier to sink in what is the issues that I'm talking about. So the right to confidentiality consists of all identifiable information about patient health status, medical conditions, diagnosis, prognosis, and treatment. And we have to keep it confidential after death, even after death. Confidential information can only be disclosed if the patient gives explicit consent or if expressly provided for in the law. So the EHDS would be the situation here in case. Information can be disclosed to patients, to other healthcare providers only on a strictly need-to-know basis, unless the patient has given explicit consent. So again, the principle of minimization included. Also in the International Code of Medical Ethics, they add something more. So they add that in point 22, a physician may disclose confidential information if, and again, if patient provides voluntary informed consent, or in exceptional cases when disclosure is necessary to safeguard a significant and overriding ethical obligation to which all other possible solutions have been exhausted. So you have their requirement, even when the patient does not or cannot consent. The disclosure must be limited to the minimal necessary information, recipients, and duration. So we see few exceptions are accepted and established by law and to protect a higher interest. So imminent death, danger, life of others. I was also curious when I was preparing for this panel to see how was the definition in Portugal. So they have in the Portuguese statutes of the association what the doctors have to comply, and so there it covers all facts that come to the attention of the doctor in the exercise of his profession, and because of it, it includes facts revealed by the person at his request or by a third party, facts perceived by the doctor. Also, professional secrecy exists whether or not the service have been required or have been paid. And one point that I found quite interesting was this. Doctors are forbidden to send patients for diagnosis or therapeutic purposes to any entity not bound by professional secrecy. So I found this quite astonishing. And also the fact that just for seeing a doctor, you are already covered by, it's confidential, that kind of information. Because on the type of the doctor, you already might know what disease that person has. So just in terms of the evolution of the concept. Yes, the concept evolved in time, and this because there had been many attacks in the past to medical confidentiality. And just to give you a little bit of a hint, in the 16th century was more the pressure on physicians to disclose patients with syphilis. On the 18th century was more relatives and friends because they were looking to know about hereditary diseases in terms of if it could jeopardize the descendants, or death prognosis, to know for the inheritance cases. In the 19th century, it appeared the pressure from employers to check on the patient's compliance and employees' behavior, and also insurance companies, because they wanted to decide on the right to reimbursement. And here it was also a funny finding was that, for example, tiredness was considered laziness, and so no right for reimbursement there, or nervosity or anemia were considered personal flaws, so also no right to reimbursement there. And in the 20th century, we see also pressure again from authorities to disclose information where the lives of others could be in jeopardy. So we had discussions about the plane pilots or the truck drivers, or also the cases of imprisoned patients, if they were already fit enough to leave prison and not putting the jeopardy of others. Now in the 21st century, what do we have as pressure? I think there is a general call for health data sharing to boost the data economy. So the purpose is not only scientific research, there are also private and other purposes in Article 34, and so we still need to see who is behind it and how we are going to change and think a little bit more about this. So in our view, we think professional secrecy needs to be safeguarded, and the HDS has not done that for the moment. The provisions will hinder the patient-doctor relationship, trust, and the principles of medical ethics. Medical confidentiality is, as you've seen, instrumental to the doctor's activity, and this because the patient can find information to the doctor to make the diagnosis more effective and efficient. So it's because it's necessary and it's in their benefit. So they are not sharing data on an envy just to share. And they also know that the information will not be shared further unless it is needed or to discuss with other doctors on their health treatment. So what risks do we see with this health data sharing? We see that patients may be reluctant in the future to provide information or seek treatment if they fear that such information does not remain secret. They can endanger their own health or the health of others if it is a transmittable diseases. They can also turn into illegal practice because they could offer the needed discretion that they need. They can also request to keep certain information out of insurance records, or, for example, avoid medical testing, or they can also request not to put that diagnosis in that way because there would be other consequences. So we know, nonetheless, that the right to confidential discussion with the doctor is not absolute right. It might be subject to restrictions, but the restrictions, and as according with the law, must not impair the very essence of the right and cannot deprive of its effectiveness. The restrictions need to be foreseeable, they need to pursue a legitimate aim, they have to be necessary in a democratic society, proportional, and only under exceptional circumstances we can justify the necessity of limiting this right. So in this case, I believe that many of the purposes identified in the EHDS do not aim the protection of health. And we can also have a discussion on what is necessary in a democratic society. So are private and commercial interests necessary? So we'll have also a further discussion on that. Yeah, I have to run up. Okay, just for this on the right to protection of personal data, what are the problems that I have seen? For example, we question here the inexistence of secure transfer environments. Disagreeing a little bit there on Anastasiya between the relationship of the doctor with the health data access body, so this is not clear in the legislation. The data management tasks that the doctor will have to do to prepare the data, so pseudonymization, anonymization, transferring only what is necessary, ensuring that you are not collecting just in view of sharing data, because the initial purpose is treatment and prevention, so you are not collecting for further processing, the time consumption, and this is not their core activity. So in the end, and last words, changes to medical confidentiality cannot be done just for the interest of one single interest group. All actors need to be discussed, and health professionals need to see the value in the process. What is being requested, as I said, is a systematic generalization of the sharing of personal health data subject to professional secrecy. This is not proportional in a democratic society. I think it is not in the legitimate aim to collect this kind of data. I will cut because I think I have to. Okay, just as a suggestion, as solution. So I think we should have a specific acknowledgement in the legislation that we need medical confidentiality and professional secrecy need to be respected. We also think that doctors should not provide data for the secondary use. Their role is to their patients, so they should only provide data for the primary use. And so we defend here the once only principle, meaning that it would be the competent authority that would be responsible for managing the electronic health record systems to make the data available for secondary use, complying with the legislation. Yes, I had it here a little bit on how we can ensure that patients can, in Article 33.5, how can they be compatible with scientific research. So I think we need to make sure that we have this differentiated approach according to member states. We cannot have this top-down imposition on how to be because of the fragmentation of the systems, different cultures and traditions. And so I think there needs to be that flexible approach by member state and also on the types of data involved. And yes, and then I'll finish. I wanted to say more, but...
I know Sara has a lot to say. This is why I tried to limit it to 2 things, which even that was too much. Thank you very much. Okay. It's very interesting nonetheless. As sure as night follows day, we are slipping on time. So I'm going to go straight to Pauline for the final presentation.
Okay, thank you very much for having me in this panel, and the subject is fascinating and could be discussed for hours, but I will try to be brief and provide practical perspective from the point of view of the pharmaceutical industry. I have made 2 slides just to present at a glance the European Health Data Space. So basically, there are 2 platforms, My Health at EU, which is supposed to be the shared medical files gathering EHR data, lab results for medical examination, basically all data collecting during the healthcare follow-up. And we have also Health Data at EU, which is a platform dedicated to the secondary use of health data. Pharma industry is interested by the European Health Data Space in 2 ways. It is considered both as a data user and a data holder. From the data user point of view, the EHDS offers great perspectives. Pharma works more and more with real-world data to generate evidence and complement the insight clinical trial can give. And today, to access this data, it is necessary to contract with different types of partners, hospitals, or national data lakes, if by chance they exist. Then the prospect to have a single intermediary who can guarantee quality data sharing and the respect of patient rights is promising. But we are not there yet, and the EHS proposal needs to be reviewed with a view to not diminishing the guarantees offered by GDPR, as the other panelists explained it very clearly. The EHS considers pharmas as data holder as well. In the section related to the secondary use of electronic health data, the Article 33 lists the data that needs to be shared via the platform Health Data at EU. The authorized secondary use purposes listed by the proposal are broad. We have research, teaching, public interest, innovation, and training of AI system. And the data that are intended to be shared are very different by nature. We have two main categories: all the data collected in the framework of the healthcare follow-up with the EHR data, the claims data, and even the data collected by your wellness app. And we have another category, which is the health data collected in the context of health research, and including the clinical trials. And unlike the data collecting during the care, the research data have been collected following investments by the sponsor or a research team, and this is why they are protected by IP rights. However, the European data space doesn't seem to make a distinction and applies the same governance and access rules to both types of data. To safeguard research activities, it is essential that data sharing respects IP rights and doesn't involve involuntary sharing of confidential data. And on top of that, in the case of clinical trial data, such sharing should not jeopardize the scientific integrity of the clinical trial or the marketing authorization of the drug or product. EHS proposal is not silent on these points. The Article 37 imposes to the health data access bodies to take measures to preserve IP and trade secrets. However, it doesn't seem to be sufficient. The data holder should have a central role in the governance, be able to control the timing and condition of data sharing, and besides, many amendments have been submitted to this effect. But I won't elaborate any further on this subject related to IP. And to focus on our topic today, I would like to outline the current challenges faced by pharma in relation to the reuse of clinical trial data so that we can ask ourselves whether EHS will help to solve them or not. The clinical trial data are very valuable for research. They are collected in a very controlled environment. They can be used for a wide range of research outside the clinical trial, whether conducted by the sponsor or the academic world. And unfortunately, anonymized data is not always sufficient. Some further research projects need the processing of pseudonymized clinical trial data. So how to proceed in this case? In concrete terms, how do we prepare and organize the reuse of clinical trial data for research purposes? First, it is very important to know that it is impossible to anticipate all possible future research use, and even the fields of this research. At the very minimum, for planned future use only, it will be possible in the informed consent form signed by the study participant at the time of enrollment in the clinical trial to give him or her the information imposed by Article 14 of GDPR and or to collect his consent for the secondary use of his data. But what are our two main challenges today? The first challenge is the fragmentation of applicable regulation when conducting multi-regional research. Even though GDPR has set a unique set of data protection rules, it has provided a margin of maneuver for member states to restrict or specify its rules for the processing of sensitive data. So it leads to a different approach regarding the legal basis, a non-unified application of the research exemption, and different safeguards across the countries. Thus, in some countries, it will be mandatory to recontact the study participants and to collect a new consent specific to the new research projects, while in others, an information will be sufficient. And there is also another layer of fragmentation, the laws on research on data, which are different across the country and require, for example, the approval of the secondary research by a local ethics committee. Then, from 4 or 5 countries involved, we are quickly confronted with a puzzle of legislations and uncertainties regarding the rules to be followed, the committees to be consulted, and also, which patients need to be recontacted. An important analytical work needs to be done, and the question is worth asking: how will this assessment be done in the context of EHDS and by whom? And it was, I think, part of your question, Paul. Second main challenge for us, it is very difficult to recontact the study participants after the clinical trial. Why? There are 3 main stakeholders in a clinical trial. There is, of course, the patients and the investigator in the hospital and the sponsor. And only the investigator side, the hospital, has a direct contact with the study participants. At the hospital, the data are coded, the name of the patient is replaced by a code, the subject D, and the sponsor receives only the health data with this code, and the hospital keeps the correspondence table between the code and the administrative data of the patient. And this indirect link is very difficult to maintain in the long term, above all after the clinical trial, for the purpose of the secondary research. Therefore, for the secondary use of clinical trial data not anticipated, since recontacting the study participant is challenging, the application of the research exemption planned by GDPR will be the solution. In this situation, all the necessary safeguards will be put in place. Waiver from data protection authorities may be required. However, with an appropriate technical infrastructure, it might be possible to do better and not rely on this research exemption and allow data subjects to benefit from all their data protection rights while not blocking research. So is the EHDS likely to solve those 2 challenges? Will the EHDS solve the fragmentation of rules applicable to the reuse of health data? Regarding data protection laws, it seems uncertain, and I think it was pretty clear from the other panelists, as the unique set of rules suggested by the proposal clash with some local data protection laws. And I will take the Italian example, which imposes a collection of consent specific to the research project. So the EHDS proposal might not be the appropriate vehicle to solve this fragmentation, even though it was part of its ambition. Harmonization of all data protection law or an amendment of GDPR to remove member state margin of maneuver will certainly be the most effective way to get rid of this fragmentation. And in any cases, we will have the second layer of fragmentation induced by research on data laws. Regarding the second challenge and the difficulty to recontact study participants, one could have imagined that the ambition of the European Health Data Space would have been to set up a platform allowing the data to be put allowing the data subject to be put at the center of the system and to fully exercise his rights guaranteed by GDPR. And it doesn't seem to be the case, as EHDS explicitly derogates from the transparency obligation. According to the proposal, health data access bodies shall not be obliged to provide specific information under Article 14 of GDPR to the individuals. Only general public information will be made available. Why is this derogation, and is it impossible? Does it involve disproportionate efforts? It's not justified in the proposal. And with My Health at EU, the EHDS wants to create a shared medical file allowing each citizen to access his or her data. Couldn't we imagine using this same channel to inform patients about the secondary use of their data, for example, wouldn't the EHDS be the technical means to allow this permanent link between the study participants and the sponsor, for example? And to finish, the EHDS shouldn't be a missed opportunity to create a link with the EU citizens, allowing them to fully exercise their rights, opt-in or information, and opt-out. And I will stop there, I think.
Thank you very much, Pauline, and to all participants. So I believe now we have about 15 minutes for questions. I won't ask any more questions because time is short. I've been instructed that if you want to ask a question and you are happy to be videoed, please step there. So if you are comfortable with this, please do it because it's easier for everyone to hear you. If not, of course, there's no obligation. So can we see hands? Please ask concise questions that can have concise answers. I know that's a lot to ask, but this way we will get more questions in. Yes, yeah, you, sir, you're closest to me. Thank you.
Hello, can you hear me?
Perfectly.
So my question is, if you're saying that consent as a legal basis still has a place in the European health data space, considering that secondary use of personal data is not dependent on consent, do you think it still has some sort of a place in this framework?
Okay, this was a broad question, so I direct this to Anastasiya because hers was the most conceptual in terms of presentation. The others were more specific. So what's your opinion, Anastasiya?
Okay, I'll start and then I'll also give the floor to our co-panelists. So consenting or not is kind of the huge discussion between like interest behind the data space. On the one side, there are fundamental rights to data protection and so on. On the other side, it's super complicated, as we already discussed, to do that, to use the data with the consent. It's kind of obstacle in that regard. So on the other side, are economic interests and like societal interests and so on and so on. I liked kind of the approach in between of the European Parliament that was also presented in the draft to have opt-out. It might be the compromise between two types of interests because it gives a choice, but it's still like by default gives the data to the whole flow of the data usage. So I think it might be the solution, but it's a very difficult topic. I don't know if the co-panelists can.
We'll take one more from the panelists on this question. So go on, Sarah.
Okay, well, for us, as a doctors, we see this was a core issue in terms of medical ethics, so you cannot do something without the patient's consent. And when this is not the case, there is a strong involvement of ethics committees, because sometimes, indeed, you cannot ask for consent. And then, so you need to have the ethics committees that does the analysis if the data is necessary, if you can, if it is proportional, the question that you are doing, if there will be any detrimental effects for the patient, and so on. So in our view, as I was saying, we cannot have this uniform imposition, because in some countries it's consent, in other countries it's the right to oppose the disclosure of personal data, and so it's very hard, and it depends also on the types of data. In terms of genetic data, you have different situations. So for us, we are more for a flexible approach and leave it at national level, but we see that member states are progressing at national level on this, so according with their traditions and culture, and so many of them are now adopting the opt-out approach, as Anastasiya was saying. So I think this is something that will evolve.
Okay, thank you very much. Next question. Yes, Nerea, front row, please.
Hi, my question concerned the data quality requirement. So we know that in medical research there's a glaring problem. You lack a diversity of so data from gender, in terms of age, in terms of ethnicity. Is the data quality requirement in the proposal, do you think it will solve any of that? Do you think it should be formulated differently? Does it even help with that? So to avoid garbage in, garbage out, so that we don't only end up having sharing of, men of a certain age and certain ethnicities data, or are we going broader than that? Does the data quality principle of the proposal help?
To whom?
Does anyone have a burning opinion? Pauline.
I think it's like if you are doing a research, you need to identify your population and avoid bias. So I think it's about data quality, but it is also, if we are talking about research, controlling the way you are doing your research, and there, like, it is not about only data protection, and I think EHDS, it is regulation around the research, and also like if you need to publish your results, like the journals are definitely a big role in that. Yeah.
Okay,
Yeah.
and a word from Anastasiya, I think.
Yeah, I have a burning opinion on that.
A concise word.
So yeah, I just also verified. So there is like the whole article on that, and I just checked that there is the requirement on coverage of data, so representation of multidisciplinary, representativity, and so on. But also there is a lot of requirements, and they're quite detailed. I think it's really a good list of requirements in terms of quality. But also, actually, the issue that you raised, that data might be not representative, when you have access to data from different member states, from different stakeholders, from different areas, that might help to solve the issue also, I think.
Okay, next question, you, sir.
Let me talk about, I heard consent is really difficult, forum shopping, divergences between national laws, problems about trustworthy at local level data processing by hospitals. Really difficult to conceive how about the data access bodies will act, and especially it could be at the end of the day a processors of data, because there will be countries with no possibilities to process data. I could add a lot of issues, but why we are assuming a law that is not considering research interests, well-being interests, how we are researching, how we are investigating in health in real world? Why I must assume a rule that works from data protection to health, to well-being, and no from well-being to data protection? Let me say, I'm a constitutional law professor. Why we are assuming that an individual right can be balanced with a general interest on public or private healthcare investigation? But we are doing this so difficult law, because let me say, I am applying this in real world, and it's so difficult. At the end of the day, you are dealing with a national DPO that is forbidden all you want to do. You have no confidence with your provider. Let me say, this is the moment to promote changes in this law. And one additional question, why we are applying GDPR to anonymize data? Yeah, we're applying GDPR strategies to anonymize data. In fact, in the first version, we are talking about controllers of anonymized data. And we are defining joint controllership between the data holder and the data access user, where the data holder has no control about the processing of data.
Which question you want answered in particular?
Why we assume that?
Why?
Are you critics? Have you any critic?
The broad why and EHDS.
Yeah.
Go. Who wants to go?
I can just say like some.
Yes.
Well, I think this is one of the main problems, right? How this will work in practice, whether all the angles can be considered. Of course, from the EDPS and EDPB side, the opinion focused on data protection, but I think it's even clear from the opinion that the practicalities of this proposal, even if you only look from the angle of data protection, are already very difficult to imagine. So, yeah, I don't think we're assuming that it's going to work. I think it's rather the contrary. It's pretty clear that how it is, at least, it's not going to work, basically. But
No, it was just for the anonymization. So rendering the data anonymous, you are still under the General Data Protection Regulation. So you still have that. And also certain data cannot be anonymized, as we had the genetic data. And then there is also the whole discussion of what is the level of anonymization that we are requiring in this. So there is a lot of discussion still, and in terms of pseudonymization. And also, again, for the practicalities, which is always what we are seeing as a doctor, how will the doctor do this kind of activities? How they will anonymize the data and send it to the health data access body? How is going to be this process? And we're also talking about the data quality. In which kind of formats are we going to do? They will already have to adjust for the electronic health records, and there will be a specific electronic health record exchange format for this. But how are they going to share this data with the health data access bodies? In bulk like this, or they just have a request and say, I want people with diabetes that you have, or people that have performed abortions because you want to study the aging of the population. So is the doctor going to do the triage and send only what is the minimal information? These are all answers that are going to be left to delegated or implementing acts, and this is not sufficient in our point of view. So for us, it was really clear there has to be a clear cut on the doctor is with the patient, and they should not be doing this kind of activities for secondary use.
Yeah, I might just say the why EHDS question. I mean, I'm not inventing this answer. I've heard it many times, but I find it particularly compelling. We all know there is a risk to individual rights in terms of privacy and other informational harms. That's impossible to argue with. On the other hand, you have to look at the cost of inefficient health data sharing, all the drugs that could have been invented which have not yet, in more efficient and more representative medical devices. For example, if you wanted to work better with different ethnicities and genders, this will be facilitated. Yeah, I could go on. These questions are hard. These losses, harms are hard to quantify. And we do know from research that the amount of research using secondary health data is increasing. So there is clearly a demand. So the question is the balance. That's the why. I mean, whether the balance is correct or not. Yes, of course. Yeah.
How to do it possible
yes.
in a practical and real way.
Yes.
Not from theories, not from building a structure that would be impossible to fulfill.
Yeah.
This is my main concern. I'm in your side.
And it's a valid concern.
Well.
It's a valid concern, without a doubt. And one last question, the gentleman in the white. Depending how quick you are.
Well, it is a bit of a conceptual question, but I'll try to rush that a little bit.
Yeah.
First of all, thank you for the presentation. That was really great. So my question revolves around Article 44 of the proposal and the way that it relates to the principles of data minimization and purpose minimization, limitation, excuse me. Essentially, these are sort of 40-year-old ideas that we've inherited from Convention 108. And my question sort of comes to the point, do we really understand the way that these principles relate to this new European health data space law? Because my concern is that we cannot really respect both of them at the same time and do that properly. And if that's true, if you want to go with that assumption, then the next question becomes, are we ready to let one take primacy of the other? And are we ready to sort of accept that these new needs that we have take primacy of over 40-year-old ideas? Or should we have the European health data space be converted to be respectful of these ideas? So just sort of your thoughts on that would be great. Thanks.
Suggest our EDPS colleague.
EDPB?
B. Oh, sorry. Yes. Subliminal.
To be honest, I disagree. I don't think these two principles are contradictory. I think they complement each other. You have the purpose limitation principle, which entails that you have to process personal data for specific legitimate purposes. And then you have the data minimization, which entails that you have to process the data that you need for that purpose. So I think they go hand in hand together. So I don't think you have to give away one in order to fulfill the other. I think they have to be considered together, and this is also why the broad purposes that are in the proposal are a big, an area of concern for us, because it has an impact also on the data minimization principle, for example. So yeah, I disagree with the premise. So.
Okay. Our very last question. I'm very sorry to the others, but we are constrained, unfortunately.
Thank you so much. I'm making this quick. So yes, it's not only 40-year-old ideas. These are rooted in constitutional law. And so, yes, I think it makes sense to keep them. But my question is, we've talked about controlled environments and how clinical trials use data today to do science. And so I was wondering if we have all this kind of complicated setup today to do clinical trials, including asking people for consent, and this seems to be working pretty well for people at the moment. Why would we do away with it? And do you people on the panel, and I guess particularly the colleague from Sanofi, who is doing the research then in the end within your company, do you believe that the data that's collected by doctors and hospitals in a context that's entirely different from a controlled environment of a scientific trial is useful at all for this kind of work if it's collected by non-scientists for purposes they don't even know about? Thank you.
Yeah, I think we are going back to the data quality question. Pharma are using more and more real-world data, really. But of course, it is really important to check the data quality and how we need to have the appropriate metadata to make sure the data is collected properly. So we need to check like the monitoring and everything. But regarding the data collected by wellness app, of course, it is questionable.
Or just overworked doctors who are actually taking care of the patients rather than being the assistant scientists.
Yeah, but I don't know if the EHS is the appropriate way to solve this issue. I think we need to, because it's not new. We are using real-world data for, I don't know, 10 years, 15 years. And okay, with the EHS, maybe tomorrow, if it happens, we will have one single entry point, but we need to check the data quality. And even pharma, when sharing clinical trial data, we need to give the metadata. We need to provide to the data user the first question for which the data have been collected. Otherwise, there is a big risk of bias and generation of non-valuable results.
Okay, thank you very much. Thank you, everybody. As you see, the issue of the EHDS is unbelievably complex, and I think I will finish with the thought I started with or had in one of the questions. I am really curious about who will be employed by the health data access bodies. You know, and the amount of complex, multidisciplinary, things they will have to inquire upon, ranging from law to science, etc. The concept, to me, it comes from ancient Greek philosophy. The idea of the poetic prince, somebody who is born from, educated from birth to know everything. Apart from somebody like that, I do not know who will be able to carry out this function. It amazes me. So thank you, everybody. It's been an interesting discussion, and hopefully we can have a chat with some of you later. Thank you.